House case, people versus Jade Latham.
Case on behalf of the people.
Water Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, card holder and principal of Jade Lathan.
Your Honor, I did attempt
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and card holder of Jade Ruth Ann Lathan and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for 90.
June 6th at 9 a.m.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Courthouse case, people versus Jade Lathan.
Mr. Canatra for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Bond continued. Thank you.
Thank you.
People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I disturb the peace, and I have on file with the public defender, Kenneth Overwater, right here to my left, a character letter from my former teacher proving that I've always been well-behaved, a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community, and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of intent resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. Business matter. Thank you.
Thank you, Your Honor.
And if I can take the letter back.
I'm here, Your Honor.
May it please the court, the state appears by Jill Gillette, counting it.
And you're Isaiah Kervin, correct?
Correct. Yes, I'm here.
Thank you. All right, Mr. Kervin, there was an earlier date where you failed to appear. A warrant was issued. You were picked up on that. You posted bond. The court order was for you to appear at the sheriff's office, which you've done. So we'll move on. Today was set for a pretrial. At an earlier hearing, you had pled not guilty, or plea of not guilty had been entered on your behalf. I have reviewed the file. There was a document entitled Notice of Special Appearance by Affidavit. Mr. Kervin, did you file that?
Yes, sir.
All right. I have reviewed that. Ms. Gillette, do you wish to make a comment on it before I rule?
I do not, Your Honor.
Very well. Mr. Kervin, is there any brief statement that you want to make in support of your motion?
Oh, well, I want to ask a couple of questions before we get on to anything.
You can start.
Okay. Yes, I want to know what I'm going to be tried, jurisdiction I'm going to be tried under. Is it going to be civil or is it criminal?
I think we went through this before, and you're charged in the state of Kansas, and this is the Elk County District Court.
Okay.
So you are charged with operating a motor vehicle without a valid license. That is a Class B non-person misdemeanor, punishable up to 6 months in the county jail and a fine not to exceed $1,000.
Yeah, so I still don't understanding. I don't understand. Is that a criminal or is that a civil? Like, is that a criminal?
Well, Mr. Kervin, I've seen these motions before. I think you well understand where you're charged and what you're charged with. So let's not fool each other here or play games, please.
No, I'm not playing any games. This so I can properly defend myself because criminal and the civil, there are two different ways of doing things. In order to properly defend myself, all I have to know which one am I going to be tried against.
You are charged in a traffic matter that is treated as a criminal. You would have the.
Here's the important legal distinction. The judge has now made it clear this is a traffic matter being treated as a criminal case. That means the defendant still has procedural rights, including the right to a jury trial, but challenging the court's jurisdiction doesn't automatically stop the case. And the judge is about to make that very clear.
Right, all the same rights that I mentioned earlier when I went through the rights. You would have the right to a trial by jury or court if you make the timely and appropriate motion in writing for the jury. Otherwise, it would be a bench trial. The duty would be on the state to prove you guilty beyond a reasonable doubt.
Okay. And you said it would be a criminal matter, you said?
I mentioned that already, how it's treated. It's a traffic case.
Okay, that's what I was asking, just to verify. So if it's criminal, if it's under the criminal, then it has the court grants this under Article 6 to jurisdiction under the criminal matter.
Okay, Mr. Kervin, I have read through your motion. I disagree with your assertions of the law. Your motion is denied. We will set this matter for trial. Are you going to be representing yourself or are you going to hire an attorney?
Well, before I go to trial, I have to know what's some questions I really have to have answered before I can enter anything so I can properly defend myself.
I've answered the questions that are appropriate. Now, your motion and the things that you have in there, again, they're not accurate statements of law in regards to these type of proceedings. Your motion is denied. So we're going to set this matter for trial. Okay. I need to know if you are going to be represented yourself or are you going to be hiring an attorney?
Can I ask what is the reason for my motion to be denied?
I've already ruled on it. It's not applicable law to this case. So, and your assertions of what the law is are inaccurate to a large degree. So I'm not going to go through line by line to do that.
No, I'm just trying to see to understand which ones you're referring to, so I can understand what was wrong, so I can know which one you're stating that's inaccurate, so I can have an understanding.
All right. So my question is, are you going to represent yourself or are you going to hire an attorney?
Well, before we get to that, I have to know how to defend myself.
All right. We're going through this cycle here, and I'm not going to play the game.
No, I'm not.
Sir, be quiet. You're here for a pretrial where you're not being responsive to my questions. If you want to have an attorney, you have the right to have an attorney. If you wish to be represented by counsel and if there's any risk to jail, typically there are times where there is a jail sentence that gets attached to this charge. You can apply to the court. If you meet the criteria, I'd appoint an attorney to represent you. Like I told the gentleman before you, that doesn't mean that you're going to be free. You also have a right to represent yourself. Those are the choices that you have. So you can hire an attorney, you can apply for one.
And this is where the courtroom patience starts running out. The judge has asked the same basic question repeatedly. Attorney, self-representation, or appointed counsel? Instead of answering directly, the defendant keeps returning to jurisdiction. The judge now has to make a procedural decision, and that decision could shape everything that happens next.
Where you can represent yourself. It's one of those three. Which one are you going to do?
Well, from my understanding, once jurisdiction is challenged, it's on to the plaintiff to prove the jurisdiction on the record.
That's at a trial. One of the issues that the state would have the burden of proving is that this occurred in this jurisdiction, which is Elk County, Kansas. That's a question of fact for the trier of fact.
But isn't it jurisdiction could be challenged at any time?
All right, I'm going to find that you're waiving your right to an attorney. I have requested you to answer that question numerous times. I'm going to set this, stop interrupting. I'm going to set this matter for trial.
Before you do that, I still have I haven't answered my question. I'm trying to understand to come to a conclusion to see how I'm going to handle my case.
All right.
You know, I'm still
you have been asking questions that are not relevant to these proceedings, and I think you're aware of that. I've seen these motions before. I've seen the people try to do exactly what you're trying to do now, where you're not going to piecemeal this out. I've answered your questions, and I'm setting this matter for trial. That would be in person at the Elk County Courthouse. Sarah, we need to have a 2-hour, stop talking. We need to have a 2-hour setting.
Okay, you correctly reflect that this court plans to bring a case against me, which it does not, will not let me know what I'm going to be facing against, because I'm just asking a question to get a proper understanding what's going against me. Because I'm not understanding the jurisdiction of this, which jurisdiction I'm going to be tried under. That's all I'm asking, just to get some type of clarification. That's it. I'm not planning the games. This is a serious matter. This is a court date. I came all this way to understand, to see how it's going, to properly defend myself. I'm not trying to waste your time.
Not going to argue with you about.
No, I'm not here to argue either, Arner. I'm listening to what you're saying. I don't want to. I heard everything. It just I want to understand what's going on, and if it's how does the trial work? If I don't,
you need to be quiet now, Sarah.
I have one question.
Sarah, no, Mr. Kervin, I told you need to be quiet now. Sarah, do you have a date for trial, please?
I have a question. If I don't want to do a trial, what's the other option?
Okay, Mr. Kervin, I'm waiting for the clerk to give us a court date, please.
Yeah, that's
nothing further.
I'm asking. You need to, because
Mr. Kervin, if I have to tell you one more time, you need to be quiet. I'm going to find you in contempt.
Yes, Judge, we can do the morning of October 28th at 10 a.m.
October 28th at 10?
Yes, sir.
Okay, our trial will be October the 28th at 10 a.m. That will be at the Elk County Elk County Courthouse. Mr. Kervin, as I've explained to you, you have the right to be represented by an attorney. That is, if you wish to ask them questions, obviously that's appropriate to do. If you're going to represent yourself, we're going to be going with what the rules are here in Kansas, not something that you've read online or in line with what you filed. So if I strongly represent or indicate that people are better off being represented by counsel, but that's your choice. But you understand what the potential penalties are. And if you're representing yourself, you're going to be held to the same standard as an attorney in regards to, being responsive and how you conduct yourself and how you present your case.
Well, I was asking about my fines. If I wanted to not do the trial thing, how was a fine, or does it have to be set for a trial in order? That's what I'm asking.
All right. If you're wanting to plead guilty, you can. If you want to plead no contest, where you're not pleading guilty, where you're not admitting to it, but you're also not challenging what the state has done, you have the right to do that as well.
Yeah, that's why I was saying I wasn't challenged. I was just understand. So how much is the fees or whatever once that's settled, would that take care of everything? And I'll need to know the amounts for whatever it is.
Well, I have told you what the maximum penalties are. I don't negotiate with people. I don't tell them what the sentence is in advance. I'm required to tell people what the maximum penalties are.
Okay, so you said the penalty was jail time, but you didn't say the cost.
I said that I said that on a Class B misdemeanor, which this is, the punishment is up to 6 months in the county jail and a fine not to exceed $1,000. Court costs on this type of case are $108. There can be other things that are assessed as well. If a person was taken into custody, generally there's a processing fee of $45. Additionally, if somebody is found guilty, if they're placed on probation, there's a fee that goes along with that. There's various things that occur with that. But as far as the penalty section, I've advised you what the maximum penalties are.
Okay, so for the fees will be like, you said like 1,000 and then about 40, so like about, almost
I said that the maximum penalty is 6 months in the county jail and a fine not to exceed $1,000.
Okay, so do you have a number for me so I can see if I'm able to pay to see how much I would, if I can even.
Okay, Mr. Kervin, what you're doing is asking me to give the sentence before you pled guilty. We don't do that. I've explained that.
If I do the no contents is what, so I'm not arguing with you, you know, I'm just, if you said no contents is not an argument. So if I do no contents, what am I looking towards?
No contest. It's the same penalty. A no contest, you're not challenging what happened. What happens then is we ask for the state to proffer what their evidence would be. That means they make a statement to the court. If the factual basis that they recite, if that was their evidence at trial, then a person is found guilty. It's not a situation where you get to contest that. If you're wanting to contest what the charge is, that's what a trial is.
Okay, yeah, that's why if I want to do the no contents, I want to see what the state would have to say. That's what I'm trying to see if we can take care of this and resolve this, because I'm not arguing with the courts.
All right. Have you been in contact with the county attorney's office prior to the court proceeding?
No, just today, just right now. I believe I sent a copy of my documents, but I haven't spoke to them anything about anything else.
All right. The court is not a part of any negotiations that can occur between the person charged and the county attorney's office. Ms. Gillette, are you willing to speak with him if I call a brief recess?
Sure.
I didn't hear your response, Ms. Gillette.
Sure. Yes. Sure.
Okay. Mr. Kervin, if you want to speak with the county attorney about what her recommendations would be, I'm going to do what they call a breakout. And so we'll be putting this case on pause. On the screen, will ask for the person to click it for the breakout room. Then you have, that's basically a private conversation with whoever's there in the room with you and then the county attorney. It's not being broadcast out. It's not something that I hear. So I'll grant a brief continuance and we'll be in recess for that. And if the clerk would do the breakout room, please.
Okay.
All right. Record will reflect that both the defendant and the state have returned from the breakout room. So we have the same appearances as before. Mr. Kervin, did you get an opportunity to speak with Ms. Gillette?
Yes, we spoke, and I believe we came up to an agreement.
All right. Ms. Gillette, is that correct?
Yes, Your Honor.
And what's the agreement as you understand it?
He's going to plead no contest to driving without a driver's license. And my recommendations are going to be $100 fine, court costs, no jail sentence, pay in 60 days. And that if he doesn't pay, his license would be suspended. He does have a cash bond that he paid cash. He would consent to any fines and costs being taken from his cash bond. There's a form he'll need to sign at the county district court office over here, and then any difference would be refunded to him. So he does have the money here, and it will be paid out of the cash bond he has on file. I did look up; I believe it is a cash bond, and the difference would be refunded to him. Those are going to be my recommendations.
Okay, so you're recommending a $100 fine and court costs, is that correct?
Correct, Your Honor.
All right. Mr. Kervin, is that your understanding of the agreement?
Yes, sir.
Okay. Mr. Kervin, you need to understand, like I mentioned before, The court is not part of the plea negotiation process. So I'm not bound to follow the recommendations that the parties make, even when they've agreed to it. The court could sentence you to the maximum that I told you. I'm not saying that's what I'm going to do, but you need to understand that that legally is possible.
Yes, sir.
Okay. With that in mind, is that correct? You still wish to proceed with a no contest plea?
Correct.
All right. Do you understand that with a no contest plea, you'd be waiving your right to a trial?
Correct.
And has anybody forced or coerced you in some fashion to make this decision?
No, sir.
Very well. Ms. Gillette, what would the state's evidence be if this matter were tried?
Yeah, the defendant was driving home from Greenwood County. He had a case up there, and as he was driving home, he was stopped here in Elk County. They did not know that he had been in court up at Greenwood. He was stopped by Deputy Mike Nelson on February 6, 24 at 3:30 p.m. on Highway 160 and 99 Junction. He was driving a 2007 BMW with a Texas plate. He had no driver's license. I don't know if he just hasn't renewed it and it's expired. Oh yeah, I do. It was expired. And he has not renewed his license. So his license is considered expired. So he had no DL. We charged him under 8-235.
All right. I do find that there has been a factual basis that support the charge. And I do find the defendant guilty on his no contest plea. We'll proceed at this time to sentencing. Does the state have any additional statements that you wish to make?
No, Judge, just the fine court cost and apply his bond and refund the difference.
All right. Mr. Kervin, are there any statements you'd like to make before I pronounce sentence?
No, sir.
Okay, Mr. Kervin, do you have your driver's license now?
It's just an occupational license that I used to go back and forth from work, but not an actual license. It's just like kind of like a work permit type of thing. And I'm not driving. I came here with my family member to bring me here to come to this court.
Okay. I'm not familiar with, is it Coolidge, Texas that you live?
Yeah, I'm in San Antonio now, but that's where I was staying at before.
Okay.
At the time.
All right. Texas requires a driver's license. And Kansas and Texas are a lot like each other in the sense that most people to get to and from work and so forth need to be able to drive. I strongly encourage you to get a proper driver's license. I'm going to pronounce sentence now. I'm going to impose a $100 fine, and I'm going to assess court costs in the amount of $108, which is the statutory amount. I've considered giving you a jail sentence. I'm declining to do so. So there's not a jail sentence imposed. However, I am going to require that this be paid. And you have cash bond that's here in Elk County, or did you post that down in San Antonio?
It was Republic. It's in Kansas, where I got picked up. I think it's Republic County or something. Where I bailed out there.
Let me check with the clerk in a minute and see if they've got that transferred up here now. Sarah, can you answer? Is there a cash bond on hand for Mr. Kervin?
Yes, sir. We do have a cash bond posted for him.
And is it in excess of $208?
Yes, sir. It was $2,500.
All right. Okay, so Mr. Kervin, following this here, I'm going to order that you pay that today. You have the cash bond on hand. You can come over to the clerk of the district court. They've got some paperwork for you to do in regards to that. So you'll be paying the $208. They'll be refunding the other funds to you, and that will complete this case. Again, I strongly encourage you to get a driver's license. You're a young man still. I'm sure you're going to need one for work and various things. And the vehicle apparently was properly tagged. This isn't a case where a lot of times some of these things we don't have a tag and there's no insurance, and you're not charged with those. So I'm assuming you had those things. But you can really get yourself in a bind if you keep accumulating these type of charges. And most states will generate a license for you and then suspend it, which, and in Kansas, I can't speak for Texas, but in Kansas, there's some mandatory jail time on driving while suspended. So, for your benefit, I'd strongly encourage you to get a valid driver's license. This matter is adjourned and the parties are free to go. Thank you.
This is Mr. Valentine, whose matters I believe are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again? Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding.
Now the stakes just went through the roof. The defendant is claiming he has a constitutional right to drive without a license and is asking the prosecutor to produce a contract with him. But the court is looking at something very different: the defendant's prior failures to appear and the underlying DUI allegations. And moments later, the judge delivers a decision that changes the situation dramatically.
And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately, and then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law-abiding in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns, and don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Or what jurisdiction are you traveling under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
Is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm a serious jurist.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? Supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously. Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
pre-trial, then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
You can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that. So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, man.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Denied the right to defend myself. You want me to hire someone else to do it? I'm a sound
I'm
mind
not
body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel, we can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of the.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have advised.
Okay, I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
Do you have any questions for me? Other than that? No, I'm not attempting. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
people of
just
special appearance.
No. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you. Folks, I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to.
I object to that. You're not allowing me.
We'll note your objection. Thank you.